Welcome to the National Crime Victim Law Institute's online toolkit. Toolkits, which include a combination of videos, downloadable resources, and other interactive exercises, are part of a larger universe of resources that NCVLI offers. In addition to these toolkit resources, you can visit NCVLI's website at www.ncvli.org to access additional free resources, including a number of in-depth articles in NCVLI's Victim Law Library. You can also visit our website to request additional technical assistance and trainings on victims' rights-related topics.
A crime victim sentencing memorandum is a legal document that victims file with the court before sentencing, in which they can communicate significant information and make a variety of arguments related to a defendant's sentence. A sentencing memorandum is one means of augmenting a victim's voice in the sentencing process. In this video, we will discuss why, how, and when to file a sentencing memorandum. By the end, you should be able to describe 5 reasons why victims file sentencing memoranda, distinguish victim sentencing memoranda from other expressions of victim impact information, identify 8 key topics to cover in a sentencing memorandum, and articulate when to file a sentencing memorandum, what factors might complicate a timely filing, and how to respond to such complications. We have invited victims' rights attorneys Colleen Clace, Victor Stone, and Elizabeth Well to join NCVLI in discussing this important subject. Throughout this video, they will share with us their experiences and advice for filing sentencing memoranda. A sentencing memorandum serves 5 main purposes: to advocate for a specific sentence or condition of sentence, to present the victim's perspective on the sentence, to provide the psychological and emotional benefits of being heard, to assert and exercise the victim's rights, and to address any other sentencing-related issues and filings. We will now talk more about each of these purposes individually. Prosecutors and defendants routinely file sentencing memoranda in support of their position on what is an appropriate sentence. A sentencing memorandum is a tool through which victims can also advocate for a specific sentence and specific sentencing conditions. In some instances, the victim may agree with the prosecutor's sentencing recommendation. One instance in which the victim and the prosecutor may disagree is a case in which the prosecutor enters into a plea agreement with the defendant, restraining the government from advocating for a particular sentence or requiring the government to seek a reduced sentence. Because the prosecutor does not represent the victim is not bound by the plea agreement and may file a sentencing memorandum with the court arguing why the sentencing component of the plea agreement should be rejected and a different sentence should be imposed. Ultimately, whatever sentence the victim advocates for is up to the victim, though they will want to be cognizant of any statutory maximums that apply in a particular case and be familiar with the range of sentences and sentencing conditions typically ordered in that jurisdiction or by that judge under similar circumstances. One important note about including a sentencing recommendation in a victim sentencing memorandum is that victim sentencing recommendations are generally limited to non-capital cases under the 2016 case Bossy v. Oklahoma, in which the United States Supreme Court held that a victim's family member's sentencing recommendation to a jury during the sentencing phase of the case violated the defendant's Eighth Amendment rights. A sentencing memorandum can also serve a victim's interest in having the court consider their perspective on what sentence will best reflect the seriousness of the crime and will provide a just punishment given the circumstances of the case and its aftermath. For instance, a victim can use a sentencing memorandum to describe the nature and extent of the impact on the victim by including information regarding any physical, psychological, emotional, financial, or other harms that the victim has suffered or is expected to suffer during and after their victimization. Courts may give the seriousness of the offense and its impact on the victim controlling weight when making their sentencing decisions. Additionally, a sentencing recommendation is a direct expression of victim impact in a language that courts can easily understand. It provides victims with a voice in the sentencing process that does not depend upon how eloquently or precisely the victim can verbalize the impact of the crime. It also gives victims a voice in cases that resolve in a plea agreement. In such cases, the victim sentencing memorandum may be the first opportunity the court has to consider the victim's perspective on sentencing. Even if the victim agrees with the government's sentencing recommendation, they may have their own views on why such a sentence is appropriate. Expressing these views in a sentencing memorandum can strengthen the government's argument for the sentence. A victim's perspective on a sentence may also include unique information and insight regarding aggravating and mitigating sentencing factors. The victim can use the sentencing memorandum to explain why and how certain aggravating or mitigating factors do or do not apply. The opportunity for victims to communicate the impact of the crime and their views on sentencing can be a beneficial and empowering participatory moment for victims. There can be significant restorative and healing benefits to expressing to the court the substantial and long-lasting effects of the crime and communicating how a sentence fits this impact. Even if a sentencing memorandum does not persuade the court regarding the sentence, the document itself recognizes and catalogs the harm that the victims suffered as a result of their victimization. To the extent that such recognition validates the victim's experience, the sentencing memorandum has value beyond its effects on a sentencing decision. A sentencing memorandum is also the means by which victims can assert and exercise a number of their legal rights related to sentencing. Although the nature and scope of victims' rights vary by jurisdiction, the sentencing-related rights that we are talking about now generally exist in some form across federal and state jurisdictions. A victim's right to be heard is the right to express the victim's views to the court and other entities tasked with making decisions related to a criminal case. A victim's right to be heard at sentencing is now a clearly and universally established part of both the state and federal criminal judicial systems and is enshrined in constitutional amendments, statutes, and rules across the country. Methods for exercising a victim's right to be heard at sentencing generally include making written, oral, or audiovisual victim impact statements before or during a sentencing proceeding and filing legal sentencing memoranda in advance of such a proceeding. For this right to be meaningful, victims must be able to provide the court with information specific to its sentencing determination. All states and the federal government offer victims some rights with respect to the request or receipt of restitution. Restitution is a condition of sentencing that may be addressed in a sentencing memorandum. It is important to note that even if restitution has already been requested separately, victims can include a restitution request within the portion of their sentencing memorandum in which the victim states their sentencing recommendation. If documentation and legal analysis supporting the restitution request has already been or will separately be submitted to the court, the sentencing memorandum can reference those materials. Another common right that is implicated in the sentencing process is the right of victims to be treated with fairness, dignity, and respect. Treating victims fairly and with respect for their dignity includes taking their rights and interests into account in the sentencing context. Defendants and the government routinely submit their sentencing recommendations and supporting analysis to courts through sentencing memoranda. A victim's right to fair treatment requires that, as another participant in the sentencing process, the victim is able to present their opinion and any supporting arguments regarding an appropriate sentence. Victims may assert and exercise their right to protection in a sentencing memorandum by arguing for the imposition of a sentence or sentencing condition that protects their safety, such as sentences involving incarceration or sentencing conditions that limit a defendant's contact with the victim or require the defendant to participate in a treatment program. In addition to asserting and exercising all of these rights within a sentencing memorandum, the filing can also be used to assert rights related to upcoming sentencing proceedings. In particular, when filing a sentencing memorandum, victims can assert their rights to notice of and presence at such proceedings. These rights are common in most jurisdictions. A sentencing memorandum also provides victims with an opportunity to address, in writing, any misstatements or other errors within the pre-sentence investigation report or in any sentencing memorandum that has already been filed by the defendant or the government. For instance, the victim might include in their sentencing memorandum arguments as to why the defendant's prior admissions, stipulations, or testimony contradict statements in their sentencing memorandum, or the victim might use the filing to dispute how the government has characterized, for sentencing purposes, the events at issue. Likewise, the victim might use their own sentencing memorandum to dispute how the pre-sentence report's author calculated the sentence under relevant sentencing laws and guidelines, or they may disagree with the factual findings that influence the report's assessment of mitigating and aggravating factors. All of these different reasons to file a sentencing memorandum raise a question for practitioners. Is filing a sentencing memorandum standard practice for victims' rights attorneys, or is it reserved for select cases, such as those where the victim has a specific sentencing recommendation or disagrees with the prosecutor's recommendation? Let's hear how 3 victims' rights attorneys would answer that question.
So for us, it is standard practice to file a sentencing memorandum. We've gotten way too much positive feedback from the courts to not do that. And so anytime we're representing a victim who's interested in, being heard or being present at sentencing, we will file a memorandum in their behalf. The only exception would be if they really are completely on board with the prosecutor and the prosecutor has filed something that covers everything that we would want to say. But sometimes when we reach out to prosecutors, they'll say, why don't you go ahead and file something in support of me? That would be great. So we can often tag team things and make it a little bit stronger for the courts.
When it comes to sentencing, it is generally our practice to file a sentencing memorandum. However, when we have a case with a crime victim who, for whatever reason, does not want to file a sentencing memorandum, we're not going to force that upon them. We do counsel them that they have the right to be heard at sentencing in the form of their choice. That can be through a victim impact statement they make or through a sentencing memorandum that we file on their behalf, or both. But we do counsel the victim on their right to file a sentencing memorandum.
It's my standard practice. And I always have a recommendation. The recommendation may be, it's never a number because the judges don't like you telling them a number, but it may be, this is a case that warrants a serious sentence, or this is a case that warrants the defendant having some time to be incarcerated without the distractions of the outside world where he can think about the damage that he did to this person. And sometimes it can be, this is a sentence where this person still is dangerous and the victim's afraid of them. Therefore, it warrants, incapacitation. But yeah, my standard practice is that. And the topics I deal with, every kind of harm that I can think of, any kind of costs, including the emotional costs and trauma that the victim is going to face, because I don't think the judges really take that into account unless the victim was a witness. And since normally cases are pled out, they don't hear the victim. They don't see the victim break down. It's hard for them to put themselves back in that position. They hear the defense counsel say, this guy is rehabilitated and ready to move on. And they hope that that's the case. And they look at it that way. And they want to help him move on. And so the victim gets short shrift. So that's why any kind of an impact that we can think of, financial, emotional, whatever it is, familial, we stick in there.
Including information regarding the impact of a crime on a victim in a sentencing memorandum is an exercise of the victim's right to be heard that is distinct from the inclusion of victim input in a pre-sentence investigation report or a victim impact statement. This chart distinguishes sentencing memoranda from pre-sentence reports and victim impact statements. A victim communicates the impact of a crime through their own words in a victim impact statement. A sentencing memorandum, on the other hand, is written to support the legal arguments in favor of a particular sentence and to otherwise influence the sentencing decision. So while the information may come directly from the victim, the tone will be different than in a victim impact statement because the victim's attorney frames the victim's words and views in a sentencing memorandum to obtain a specific sentence. The timing of delivery is another factor that distinguishes pre-sentence reports and victim impact statements from sentencing memoranda. A pre-sentence report is generally submitted first and is something that a victim's attorney might respond to in their sentencing memorandum. Written victim impact statements may be submitted to the court before or at sentencing, and oral victim impact statements will be presented at a sentencing proceeding. By presenting the victim impact information to the court before sentencing through a sentencing memorandum, the victim is able to inform the court from their own perspective of the impact of the crime before the court reaches a tentative sentencing decision based on a plea agreement or sentencing filings by the parties. Given the different voices, audience, timing, and purposes of pre-sentence reports, victim impact statements, and sentencing memoranda, a victim's attorney may consider using each avenue as a means of presenting the impact of a crime on the victim in a different light. Sentencing memoranda and victim impact statements are complementary expressions of a victim's right to be heard. When used together in a single case, they are especially beneficial to victims and to the court. Let's hear from victims' rights attorneys about how, in their experience, sentencing memoranda and victim impact statements work together.
So when we are talking to victims about what to expect during sentencing, we let them know that victims in Ohio have a constitutional right to be heard during sentencing and anytime their rights are implicated. And that for the victim themselves, that often takes the form of a victim impact statement. And for victim counsel, we like that to take the form of a sentencing memorandum. So essentially, we're just explaining to them, this is your piece, and you can do that. These are not mutually exclusive. And this is our piece. And we kind of just explain to them why the courts like sentencing memoranda, and they do. I have judges tell me every time I train them, like, I could do without this, that, or the other thing that you do, but keep filing sentencing memoranda. I really like those. And so, it's a tremendous compliment to a victim impact statement, because during the impact statement, the victim is asking for something. And in the sentencing memorandum, you're explaining to the judge why it's appropriate for the court to consider that and to potentially give the victim what they're asking for. So they work really well hand in hand. And victims, we've never had a victim object to the filing of a sentencing memorandum. They've always been really happy to have that additional support.
The basic topics that we address in a sentencing memorandum include the impact of the crime on the victim. The impact can be emotional, physical, and economic. We generally have victim impact as our top and first argument in a sentencing memorandum. We will oftentimes attach the victim's own victim impact statement and statements from other family members to our sentencing memorandum if they want us to do that. We will generally file our sentencing memorandum in advance of sentencing, and so that there's enough time to allow the judge to read and take in what the victim is saying.
When filing a sentencing memorandum, victims' counsel will likely want to start by establishing their standing to file, as well as any additional authority that the court has to consider the filing. Like the parties in a criminal case, who often file sentencing memoranda where the law does not explicitly authorize them to do so, a victim's attorney should be able to file a sentencing memorandum, even where it is not explicitly authorized, because of the victim's rights to assert and enforce their legal rights within the criminal justice process. Courts in many jurisdictions have an affirmative obligation to ensure that victims are afforded their rights. This obligation, which is written into the victims' rights laws of many jurisdictions, provides additional support for the filing of a sentencing memorandum when the victim's rights are at issue. Courts also have authority to consider victim sentencing memoranda under their broad discretion to consider all relevant information at sentencing. Federal and state laws governing sentencing procedure further support a court's authority to consider victim sentencing memoranda by directing courts to consider certain factors before reaching a sentencing determination, many of which are addressed in a victim sentencing memorandum. To serve these purposes and otherwise protect victims' interests and rights in the sentencing context, there are 8 key topics to address in a sentencing memorandum: an assertion of the victim's standing to file the motion, and the other sources of the court's authority to consider the filing can remind courts of their obligations and authority and preempt any objections by the parties on standing grounds. A sentencing memorandum can contain the victim's assertion of rights. When asserting their right to be heard in a sentencing memorandum, the victim may choose to do so broadly. For instance, if the victim wishes to provide a victim impact statement in addition to the sentencing memorandum, or even if they only wish to leave open the possibility for doing so, they can assert this aspect of the right to be heard in the sentencing memorandum. The sentencing memorandum can further include the assertion of the rights we've already discussed and any others that are implicated in the sentencing process. The victim can also argue that the defendant has no countervailing rights that prevent the court from considering the victim's sentencing memorandum. In particular, the consideration of a victim's sentencing recommendation in a non-capital case does not violate the defendant's Eighth Amendment or due process rights. Another key topic in the sentencing memorandum is how the impact of the crime on the victim supports the imposition of the victim's sentencing recommendation. This discussion may include details regarding all the ways in which the crime impacted the victim and highlight why the court should give controlling weight to consideration of the seriousness of the offense and its impact on the victim. The sentencing memorandum is also an opportunity for victims to take issue with any errors in the pre-sentence report or the parties' sentencing memoranda, such as misstatements of fact, misapplication of sentencing factors, and miscalculations regarding the defendant's sentence. A sentencing memorandum can also contain the victim's sentencing recommendation, including their position on the conditions of a defendant's sentence. This portion of the sentencing memorandum may draw express connections between the impact of the crime and the appropriateness of the sentence, as well as highlight any other factors that go to the victim's suggested sentence as being fair and fitting given the defendant's actions before, during, and after the crime. A sentencing memorandum can also contain the victim's request for restitution, including supporting materials. If the practice in your jurisdiction is to file a separate restitution request, or if the restitution request must go through the prosecutor, the amount of restitution that the victim seeks can be included in the sentencing memorandum, with references to any past or future filings or court proceedings regarding restitution. Let's hear from victims' rights attorneys about their experiences with how courts tend to receive victim sentencing memoranda.
In Arizona, judges are generally amenable to attorneys filing sentencing memoranda. There's a statutory right to have counsel of your choice and to be a constitutional right to be heard at sentencing. And the right to be heard can be in the form of the victim's choice, whether it is standing in court and reading a statement, recording a statement, or submitting a statement in writing, either in the form of a sentencing memorandum or victim impact statements attached to that memorandum.
I've never had a judge say you can't file it or send it back and strike it. So the answer is basically yes, they're open to it. And in fact, most judges will say, I'll hear the victim speak. And then after the victim speaks, he'll say, is there anybody else in the courtroom who wants to speak? I mean, they'll let anybody talk who wants to. They'll let anybody file any document pretty much who wants to. And I've had defense counsel move to strike my documents, and the judges haven't done that. Partly because I can point to the statutes that say they have a right to be heard, but also because the judges feel that's a no-win situation for them. What, they're going to exclude something and look like a fool if we appeal, and even have other judges sort of say, what were you thinking? Let them say what they want. Let them file what they want. You're going to do what you want. So no, they don't give us a hard time.
Victims may file sentencing memoranda after a defendant is convicted, either by guilty plea or after trial. A sentencing memoranda is likely to be most effective if filed well enough in advance of sentencing for the court to have time to read the filing and take into account the victim's position and arguments. There are a few factors that complicate the timing of this filing for victims. For a victim to timely file the sentencing memorandum, they must be aware of the schedule for sentencing filings and proceedings. Victims typically have the right to notice of critical moments in a case, such as sentencing, and can request notice of and access to court filings. When the government and the prosecutor have entered into a plea agreement, the victim's ability to get a timely sentencing memorandum before the court will depend, in part, on whether the victim is even aware of the plea negotiations and the resulting agreement. If they are unaware of the agreement and the court orders a sentence without first hearing from them, the victim should be prepared to challenge the order as having been issued in violation of their rights. In this video, we have covered the main issues regarding why, how, and when to file sentencing memoranda. Filing a sentencing memorandum can have a substantial effect on a court's sentencing decision, but it is only one of the ways that victims can protect their rights and interests in the sentencing context. Additional publications and information expanding upon all of these sentencing-related rights and filings can be found on NCVLI's website and elsewhere in this toolkit.
Thank you for participating in this online experience, and we hope you enjoyed it. If you enjoyed this tool and are interested in other victims' rights tools, please visit NCVLI's other toolkit resources for additional interactive learning exercises like this video, in addition to other tools such as flashcards, tip sheets, and much more. One of NCVLI's key projects is the National Alliance of Victims' Rights Attorneys and Advocates, NAVRA. Using its updated website, www.navra.org, NAVRA connects people committed to improving the justice system by providing the practical tools they need to protect, enforce, and advance victims' rights. NAVRA's tools include searchable databases of sample legal pleadings, legal memos, and key case summaries, as well as in-person and online trainings, partner listings, and the Pro Bono portal, which matches attorneys with crime victims in need of representation. Thank you for joining us. And in addition to these resources and others available on our website, NCVLI is ready to assist by providing additional research and assistance that is tailored to your needs. Please visit www.ncvli.org and navigate to the online forum by clicking the Professional Resources tab and then selecting Technical Assistance.